Good morning. Reminder that unless the court has put an order down to the contrary, the oral argument will be live streamed on the AOC site, and then the oral argument will be placed on the AOC YouTube site. Call the first case, please.
Kathryn v. Charlene S. Fields.
We'll hear from the appellant when you're ready.
Morning, Your Honor. Honors.
Good morning. If you would, pull the microphone so it's over kind of in front of you. Make sure they pick it up.
All right.
Thank you.
Is that better?
Yes, sir.
Yeah. All right. All right, my name is Curtis Isabel. I represent the appellant, Charlene Fields. We're here today on this appeal from Campbell County.
You want to reserve any time for rebuttal?
Yes, Your Honor, if I could, 5 minutes.
5 minutes.
Yeah.
That'll be fine. Go ahead.
Thank you. We had this trial on April of 24, and involved the plaintiff was the daughter of the decedent, and she'd sued the longtime companion, which is my client, Charlene Fields, for conversion, breach of fiduciary duty, fraud, and improper possession of property. We had several witnesses at the trial. The court found that my client had wrongfully transferred property or monies from a home equity line of credit to herself, and that there was a conversion of some property to value of about $30,000. We have filed this appeal timely and alleged that in our appeal that the trial court erred in finding undue influence in the transfer of the monies that I just told you about, and that the trial court had erred in the judgment for the personal property, for which there was no inventory and no foundation provided for the $30,000. So the transfer of the monies from the home equity line of credit was done before the death of Mr. Miller, and the bank president testified at the trial that he did not know them personally, that he was involved in the transfer, that the records did not reflect who made the transfer of the monies from the home equity line of credit to his bank account personally, but that there was a transfer from my client where she transferred from the bank account that she had with Mr. Miller to her own bank account. She also had a power of attorney, and the allegations from the appellee was that she had used that power of attorney to do this transfer, but the bank president testified there was no indication that the power of attorney had been used, and the trial court found that there was no proof before it that the power of attorney had been used. My client testified that Mr. Miller had directed all her actions.
Let me, there's no transcript, correct?
Yes, Your Honor.
There's a statement of the evidence.
Yes, Your Honor.
Prepared by?
Initially, I prepared the statement of the evidence.
And then did the trial court accept it?
The appellee argued that it was too one-sided, and the trial court did its own statement of evidence.
And is the statement of evidence really pretty much just by the trial court, just pretty much track its findings of fact?
It's exactly what it does, Your Honor.
Go ahead.
So, and the trial court focused on what it focused on, and my notes, indicated some testimony from the witnesses that weren't included in the trial court's judgment, and so that's why I did my own statement of evidence. Perfect world, we looking back 2020, having hindsight's 2020. If I'd had a court reporter, I wouldn't have been in this position. But anyway, the bank president testified that the power of attorney had not been used. There's no indication in the bank accounts that who made the transfer. My client testified that Mr. Miller was the one that directed all his financial affairs up to the date of his death.
Well, but see, our problem is you keep telling us what all the testimony was.
Yes, Your Honor.
But we don't have the transcript on it.
Yes, Your Honor. You've got my statement of evidence and you've got the court
We don't have your statement of the evidence. The trial court rejected it, so we have the trial court statement of the evidence.
Okay.
And I think the difficulty for you is you keep referring to this witness testified and to such and such, and this witness testified and such, but we don't have the transcript. And it's not in that, I don't think those details are in the statement of the evidence.
Okay. Well, Your Honor, the court still found an undue influence, by my client. And for the undue influence, the presumption is that there was something that had happened, as this court's aware, that the case law provides, that for undue influence, that in order for there to be undue influence, you've got to have something that benefits someone, and they had an opportunity to do that, and that it's not the influence necessarily that makes it undue, it's the entire circumstances of it. And so even without the statements of my client, the court still erred, from our position, in finding undue influence. The transfer from the home equity line of credit, whoever did it, the fact is that it was done before his death, and that this did not result in Mr. Miller being there was still plenty that was divided between the children. There wasn't a situation where this left him just impoverished, where he couldn't do anything else, and so it wasn't undue influence. It was appropriate for him to transfer the money if he wanted to. It was his decision, and the testimony from other witnesses, not just my client, but was that he maintained his financial affairs himself. That even the checks that were written, that were presented to the trial court, that she talks about in her judgment, they were signed by Mr. Miller. So there was no undue influence in that situation, because she might have had the opportunity to talk to him about making transfers, but he had the decision-making ability and was able to make those decisions, and those transfers did not leave him impoverished. The other issue before the court is there was some statements that were made that the court based its judgment on, that were statements that Mr. Miller had made prior to his death. When my client tried to rebut those statements in her testimony at trial, the court would not let her testify based on the dead man statute. Counsel had opposed it. This was not a situation where it was the distribution of assets. This was a case that was about ownership of the assets, and I cited Petty versus the state of Nichols, which was a Tennessee appellate court case that has talked about the dead man statutes and the competency of parties to testify relative to those statements, and said that needed to be very narrow in scope to exclude the evidence. And in that situation, it needed to be about the distribution of assets in the state, not about the ownership. And Petty versus the state of Nichols talked about a widow, and she was in a lawsuit with the kids of the decedent, and they were talking about the ownership of property. And in this situation, we were talking about the ownership of this money from the home equity line of credit, and in that situation, that's not, the dead man statute doesn't apply, and the court erred in not allowing my client to rebut the testimony for consideration by the court. We also allege that the trial court erred in
Counsel, did you make any, does the record show whether or not you made an offer of proof on that testimony that was excluded?
No, Your Honor, because again, I don't have a court reporter, so it's, I made an objection. The objection was made about the dead man statute, and we discussed that, but no. And the personal property, I'm going to touch on that real fast. The burden of proving the damages rests on the party seeking them, as I alleged in my brief, and they are the ones that have to establish, what was missing and how much those were worth. She did not own the property. She had supposedly gotten an inheritance of this property, and it was missing when she had actually got access to it. My client didn't testify that she didn't even know where this property was, hadn't seen it, and she presented a list with the amounts. She was not established as an expert in evaluation of property. I objected to the foundation, and the court allowed that to come in anyway. And where an owner of personal property could testify as to its value, if you're not the owner of the property, you don't have an established foundation of what it was worth or what you bought it for, then you need to have an expert to testify about it. And that was the basis of our objection to that. And we alleged that the trial court erred in allowing that to be put forth, and that was part of her judgment. Thank you.
You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
May it please the court, my name is David Winchester from the Campbell County Bar. Your Honor, as you correctly have pointed out, the record in this case is very slim. There was no court reporter. All we have is the court's own statement of evidence, which actually incorporated the court's findings of fact and conclusions of law. And of course, we have the documentary evidence and the pleadings, which are in the case. That's it. That's all we have. The issues presented by the appellant are only two. The first issue that he presented was alleging that the court erred in finding undue influence on behalf of his client. Now, as I'm sure the court has looked at, the trial court relied on the case of Ellis versus Dugan in finding that, as a matter of fact, that there was undue influence on the part of the appellant. If you look in the record, what record we have from the court's statement of evidence and the court's findings of fact, there are several things which support the court's finding of undue influence. In the statement of facts, there's several facts which are just completely unrefuted at all. And those facts are that the decedent at the time in question in April 2021 was in the final stages of terminal cancer. The defendant, appellant, Charlene Fields, was his primary caregiver. There's no evidence in the record that he received any independent advice for anything. There's also undisputed evidence in the record that on April 20th, 2021, Charlene Fields was the one who caused a draw to be made from the decedent's HELOC account.
Same question to you. I mean, are that evidence you're talking about now, is it in the trial court's statement of evidence?
Yes, it is, Your Honor.
Those things, okay.
Yes,
so
it is, Your Honor.
That's fine, go ahead.
As a matter of fact, in the trial court's statement of evidence, the court points out that the bank officer who testified was able to cross-reference the identification information that belonged to Charlene Fields to the person who made those transfers. That is in the statement of evidence, Your Honor, and in the court's findings of fact. They were able to cross-reference that with the driver's license and social security number of Charlene Fields, which was also part of the evidence, of the documentary evidence. So that was the testimony of the bank officer, and that was stated in the court's statement of evidence and findings of fact. As a matter of fact, in the findings of fact, the court states that Charlene Fields failed to dispute the fact that she deposited that $166,395 into her own checking account. The court states that in the record, that she failed to do that. In addition to that, there were 5 checks that the court determined from the evidence, and this is also in the statement of evidence, that were made for Ms. Fields' benefit or for the benefit of the property which she had inherited from the decedent. Though all of those facts, Your Honor, are completely unrebutted. There's other evidence that, again, is stated in the statement of evidence, which they were adopted by the court in the court's findings of fact. The only evidence to the contrary was just a general denial by Charlene Fields. And these items were that Mr. Miller was very weak and in pain at the time in question in mid-April 2021, that visits from his children were not welcomed by Charlene Fields, the primary caregiver, and that he was in a very emotional state and he was severely compromised.
Excuse me for interrupting, Counselor.
Yes, Your Honor.
These transfers, where in time were they made in relation to the passing of the decedent?
Within a week or so.
All of them?
Yes, Your Honor. Yes, Your Honor. The court in the statement of evidence gives the dates on those. I think the first date was April 12th, 2021, and the date of and then other ones were made within a week after that, and then the decedent died on April 23rd. The transfer of the $166,000 from the HELOC account was done on April 20th, which was 3 days prior to Mr. Miller's death. So, and that's all in the statement of evidence, Your Honor.
Thank you.
So anyway, Your Honor, the court based its decision on the case of Ellis versus Dugan, which is a Court of Appeals case, which talks about finding of undue influence. You'll note that the court, because there was no signed power of attorney in the court record, that the court did not find as a matter of law that there was undue influence present in this case. The court instead relied on the case Ellis versus Dugan and found certain suspicious circumstances and listed those in her findings of fact and the statement of evidence, and found that a number of those suspicious circumstances were present in this case. And based on those suspicious circumstances, found as a matter of fact that undue influence occurred. And took it further and said that the case required that once there was a finding of undue influence, then the burden shifted on the defendant to show that any questionable transactions were fair. And the court, in the statement of evidence and the findings of fact, specifically found that the defendant failed to overcome that burden, failed to produce any evidence that those transactions were fair. So consequently, the court awarded the value of those transfers to the plaintiff. Now, although this was not listed as an actual issue, a specific issue before the court, counsel did point out, and he did argue in his brief about the dead man statute in this case, Your Honor. And I would just say very briefly that this case and the testimony which was attempted to be produced by the defendant is a clear-cut case of the dead man statute. The dead man statute, Your Honor, as I'm sure you know, it's TCA 24-1-101, and it basically says in actions involving an executor, which is what we have, neither party is allowed to testify against the other as any transaction or statement with or by the testator. And that's exactly that's exactly the situation that we had, Your Honor. My client was the duly appointed executrix, and counsel attempted to introduce statements made by the testator, which, you know, that's square on dead man statute. The case that he cited, Your Honor, if you'll take a look at it, in support of his position, is not even a dead man statute case, Your Honor. That was a case by either a widow or the heirs. It did not even involve the executor, which takes it out of the requirements for the dead man statute. So I'll leave it at that. The case is clearly, our case is clearly a clear-cut case for the applicability of the dead man statute. The final issue, Your Honor, has to do with the personal property. My client, and this again is in the statement of evidence and in the record, my client produced or testified and produced a list that she had made about property which was missing from the estate. The court, based on her testimony, it was on her own list made from her own knowledge, and that it was her opinion as to the value of the property. The court admitted this document, which had a list of the property which was missing. Counsel argues that the executor was not the owner of the property, but I think, Your Honor, at that point, legally, she was the owner of the property. She was the executor of the estate and had the legal authority to take possession and be the owner of that property, and therefore, under the law, was qualified to testify as to the value of her own property, and the court accepted her testimony. The only evidence contrary to this in the record was, again, the general denial of the defendant, Charlene Fields. Just one last statement, Your Honor. The trial court in this situation is the authority present at the trial court level, and the trial judge is the one who's able to watch the demeanor of the witnesses and to make a judgment as to the credibility of the witnesses. I think this is clear in the law that she's able to do that, and that's what she did. She judged the credibility of the witnesses as to whether or not this property was missing and whether it was the responsibility of the defendant, and that's the decision she made. I think the law gives her the clear authority to do that. So, Your Honor, just in summary, I think the evidence in this case, as reflected in the record, overwhelmingly supports the findings of the trial court, and the court, we would respectfully ask that the court affirm the judgment of the trial court. Thank you.
Thank you. We'll hear from the appellate rebuttal.
The bank president testified about the transfer of the monies from the line of credit to the account of Mr. Miller, and then from Mr. Miller's account to Charlene Fields' account. And he testified at that time that the driver's license, the social security number of Ms. Fields was used to transfer the property from Mr. Miller's account to her account personally. And my client did not deny that that transfer was made. The part that she denied was that she had made the initial transfer from the line of credit to Mr. Miller's account. That's the part that the bank president testified that he did not know who made that transfer. No indication of that. So there was no dispute that the $166,000 was transferred to my client's account. The dispute was who made the initial transfer and who made that decision to make it. And my client testified, and the plaintiff in this case testified that Mr. Miller knew about his finances and that he remained headstrong despite having cancer. And that goes to the next point that the appellee made, was that the suspicious circumstances of the undue influence. He said because he had cancer. But the courts also, the case that was mentioned by the appellee and other cases before this court have talked about whether those suspicious activities, if you take all of it into account, whether the person remained headstrong and knew their finances and whether it left them impoverished. Well, this was not a situation where he was left impoverished, and he maintained, he was headstrong the whole time, knew about the finances and directed the finances, and there was no testimony to the contrary that he wasn't directing the finances. Yes, he had cancer. Yes, it was done days before he died, but he had the wherewithal to know about his finances and what he wanted to spend. Those were decisions that he made. And so in that situation, there's not a suspicious circumstances. Someone can influence somebody to transfer money or give them property or do things that helps a piece of property that they're going to get in a will, but it's whether they knew what they were doing and whether those actions left them impoverished, and that wasn't the situation. getting to his dead man statute argument, this was a case where the executor of the estate was filing a lawsuit, but she also filed it on behalf of herself, and the testimony wasn't about distribution, it was about who owned the funds at the time. And so they made statements as to Mr. Miller, what he said prior to his death, and the court allowed that to come in. And then when my client tried to rebut that with statements that he had told her, then the dead man statute, comes up, and she was not allowed to testify. The dead man statute doesn't apply. She should have been allowed to testify about those things if you're going to let the plaintiff testify about it, and it's not about distribution under the estate, it's about ownership of the property. And then getting back to the personal property list, again, she was not the owner at the time that it was not just her. It was her and her children, or not her and her brother and her sister, that would have been the owners eventually. But again, they did not buy those things. They got them from an inheritance from her mother, I believe it was. And so there was no indication as to if that property was even there to begin with. And then the value of those properties, there was no establishment by an expert that could testify about what those things might have been worth. And it came in over my objection for foundation. Thank you.
Thanks to counsel for both sides. We appreciate your arguments this morning. Have a good ride back to Anderson County and to Campbell County. I know. Thank you. Thank you.